Before the Human Rights Act was incorporated into British law in 2000, the UK did not have a single document explicitly outlining fundamental rights and freedoms. Passed in November 1998 and coming into force in October 2000, the Human Rights Act 1998 incorporated the rights from the European Convention on Human Rights, or ECHR for short, into UK courts. The ECHR is a treaty that protects basic freedoms like the right to life, fair trial, privacy, and free expression across the member states of the Council of Europe. The common question is there anything new coming out of the Human Rights Act 1998, or is it simply a spin on the ECHR? Here's the deal. The Human Rights Act 1998 does not introduce any new rights on its own. It simply incorporates the key rights outlined in the ECHR into UK law to make these rights enforceable in UK courts. So individuals do not need to take their cases to the European Court in Strasbourg in France. They can seek justice right in the UK. The Human Rights Act protects essential human rights such as rights to life, liberty, fair trial, and freedom of expression. It also prohibits practices that debase human dignity, like torture and discrimination under any circumstances. Now here's the cool part. UK courts must now interpret laws to match these human rights, and if they don't, judges can declare them incompatible. Let's say you joined a peaceful protest and you were arrested under a UK law that bans public gatherings. You believe this violates your right to freedom of expression, so you invoke Article 10 of the ECHR. If the court agrees with you, it could declare the law incompatible with the Human Rights Act, meaning the law remains valid for now, but it signals to the Parliament that it conflicts with fundamental rights and needs reform. Another example, imagine you're applying for a job and you're the best candidate for the position, but you're told you will not be considered because of your age, your gender, or your race. That's a clear violation of Article 14, which prohibits discrimination on any grounds. If you believe you've been treated unfairly because of something beyond your control, like your background or your identity, you can challenge this in court. And for journalists, Articles 6, 8, and 10 are crucial. They cover fair trial, privacy, and freedom of expression, but these rights often clash. Imagine balancing freedom of the press against someone else's right to privacy. It's kind of tricky. And that's where the proportionality test comes in. It's the process of weighing one right against the other to make sure any restriction is justified and not excessive. And that's a different lesson altogether. Stick around and you'll learn exactly how it works.